Hi, this is Lisa Stark. I am the Vice Editor-in-Chief of Business Law Today, and I'm fortunate enough to have with me today Jessica Pearlman, one of the incoming vice chairs of the Mergers and Acquisitions Committee. Now, Jessica, I know you've had a long involvement with the ABA. What got you interested in the ABA first, and when did you start coming to the meetings?
So it's been a long time now. I think almost 15 years. I'd have to go back into my records to check that. But the marketing materials actually worked. I was looking for ways to learn more about M&A. That's what I was doing primarily. I wanted to grow, I wanted to learn, I wanted to get better at it. And I saw that there was an entire committee. At that time, I think it was the Negotiated Acquisitions Committee. And I decided to check it out and get involved.
Wow, so that's really interesting. So you just decided on your own to go do it?
Well,
and
I had to, kind of beg for dollars to get sent to a meeting, but they took a chance on me with the firm and it being a worthwhile venture, and it really paid off.
Well, that's very impressive, because a lot of people we've talked to, they're sort of groomed to come into the ABA with other partners, but you actually, which is exactly what we're trying to encourage
Yes.
young lawyers to come and learn and grow and become leaders in the ABA.
For better or for worse, I volunteered myself.
So what have you learned over the years, and what about the
so much. Yeah, substantively so much. The M&A committee is full of people who don't just do M&A, they do M&A at the top of the game, and they want to be the best because they want to know what the new case law is, what the new practices are, what the new trends are, and they want to talk about these things, and we are all happy nerds together discussing these things. And it's really a wonderful way to stay abreast of developments and new practices and new ways of getting deals done.
And I'm sure there's also a people component of it. Have you made friends here forever? And I hear that
absolutely.
A lot of times.
Yes. That's probably the most unexpected element. I came to get better at M&A as an associate, and I've stayed all these years because the substantive information is on point and the people are wonderful. When I'm traveling, not just for work, when I'm traveling with my family, I'll meet a friend in San Francisco for coffee or a friend in LA for dinner that I've gotten to know through the committee. It's really a wonderful group of people.
And what about in terms of leadership? I know you've been a past chair of the Market Trends Subcommittee. You've also been the chair of the Deal Point Study for the private target merger agreements. How do you think it's developed you as a lawyer? I know for me personally, it's been really helpful. The ABA tends to grab people who are willing to put in effort and to promote them. Have you found that to be the case?
Absolutely. If you show up and do what you said you were going to do, you will have opportunities for leadership, because that's exactly what the ABA is looking for and what we're looking for the new generation of leaders moving forward. I really enjoy project management roles. A huge part of being an M&A attorney is project management. And we have so many interesting projects coming out of the M&A committee. Not just the Deal Point study that you mentioned, but right now I'm working with the chairs of the Model Asset Purchase Agreement on a revised version of that. So really interesting products.
It's terrific content. I know that, we're very interested at Business Law Today in your content, and we'll hope to share it with it because it's world renowned. Everybody wants it. So that's a really exciting thing to do. So let's talk a little bit more about the most recent Deal Point study. So the most recent Deal Point study looked at deals completed during through the first quarter of 17.
First half. Yeah,
okay.
We did a year and a half this time. That was one of the differences with prior iterations. We wanted to make it a little bit more current because we have to review the deals after they're done, so we're always doing it a little bit after the fact. So we added another half year of deals in to the mix. And we look at mid-market deals. Now, mid-market is defined really broadly. Basically, we look at deals below $1 billion with some type of floor, depending on what the pool of deals look like for the given time period. The other thing to always keep in mind with the private target Deal Point study, obviously it's private target, we just said that, but it has to be public companies for us to get our hands on these agreements, and not just any public buyer of any private target, but material enough to the public buyer
That
for
they
it to
had
be
to
filed with the SEC in the first place. So we always have to think about what does that mean on leverage and how does that skew the results in terms of what we're getting back as a data set.
And how does that sort of all come together? I know I've seen sort of the private target, the cover sheet, they're just lists of issue group leaders and a chair, and how does that all come together?
Yes.
Do you guys just coordinate with each other? And
yes, so as the chair, I'm the chief kitten herder. And then we have issue group leaders for different areas, 2 for indemnity because it's such a broad topic.
Right.
And within each of those working groups, with those issue groups, there's a working group that actually is reviewing the underlying agreements, and there's a process for QCing that for quality control where they trade documents and review each other's work and worksheets that get filled out. We're working, I think, that what you'll see in future iterations, we're working with AI to figure out how to modernize our approach. And so it's really interesting to see what we can do in that regard.
Right, so I guess right now somebody was just pulling stuff from the SEC and searching
yes. And I think we'll always have to have a human element of confirming that some of these provisions are so nuanced. We can have an hour-long, like I said, happy nerd discussion about whether this counts as a non-reliance provision or doesn't. And as you know, as a Delaware practitioner, recent case law changes our perception of that and then how we want to reflect the data in a way that AI is not going to know about. So we have to add that human factor for sure.
Sure. And what were some of the highlights of the most recent deal point study in your mind?
Well, so we did make some changes. One was, I said, to make it more current.
Right.
Another is that we took out divisional sales because we have another publication chaired by Rita O'Neill on carve-outs. And so we wanted to be able to compare apples to oranges, if you will, fully without having her data baked into ours. So we excluded that. And then the biggest thing I'd say that's different in the most recent iteration is, in addition to, we always have new data points, but one whole entire section of new data points was on reps and warranties insurance, which is a really growing trend in M&A.
And how can having this data help you in a deal? Do you use the deal point study in your practice?
I do, but I don't use it in the way you might think. I don't ever brandish it and say, see, look, opposing counsel, it says X. I think it's best used as a way to confirm your thinking about your approach, whether you're in a reasonable range on an issue. I do a whole spiel on do's and don'ts when I present on the study, and one of the do's is using it to educate yourself, to educate your team, to educate your client, depending on the sophistication level. It's a great way of explaining what a deal point is all about. It's never good for chest beating and saying this is what's market.
Right. And
you don't know what's been horse traded, right? You don't know what's been given in order for that provision to have been gotten in any given deal. There's no one metric that tells you whether a given deal was buyer friendly or seller friendly.
Sure, it's all about the power ratio, right?
Exactly. So it's about I think double checking yourself and seeing do other people view this data point the way I do, generally speaking.
I know I was doing a deal the other day, and of course we've had a vast increase in the number of appraisal proceedings in Delaware. And so I was talking to another partner, and we were trying to figure out whether we were going to include a closing condition relating to appraisal rights. And I was like, oh, that's still a minority of the deals. And he's like, no, it's not. Take a look at the most recent study.
And again, context matters, right? Public buyer, private target, or whichever study you're using. European study just got released on recently. Whichever study you're using, you have to think about the context of who the parties were to these deals and whether that fits your given situation.
Right.
It might be that you're doing a tiny deal below our threshold, and it might not be the same. Applying a percentage for a threshold on indemnity doesn't make sense across the board in all these deal sizes. The mid-market is a very wide range.
And so I think one thing I wanted to come back to, it's sort of interesting to me to see how some of these younger lawyers who have volunteered to help eventually become issue leaders or issue practice leaders. And then eventually we've seen, for example, I'm thinking of Lisa Murison or Rita O'Neill, who at some point were issue leaders and eventually became chairs of entire separate
Rita Ann is now chairing the Market Trends Committee, or Subcommittee, excuse me. And there's plenty of opportunities like that. I think it's like anything we do. If you show up and you deliver on what you said you were going to do, there will be opportunities for you, and that's what we encourage.
Now, how does your deal point study differ from the international deal points? That's a little different, right? They don't have a public database?
There's no public database. So for the Canadian study, there's CEDAR, which is the Canadian sort of analogy to EDGAR, the SEC database. There's no equivalent for Europe. So in Europe, there's been volunteering of deals for review, with scrubbed identifying information because they're still confidential as to who the parties are. Obviously, do you hand over the deal where you didn't like the terms that you had to agree to?
Right.
And so you have to think about
we won't submit this one.
Yes, but I still think it's very helpful to see what are other people doing out there in their deals.
Now, you're also involved in the Women in M&A subcommittee. Tell me about that. What's that?
Yeah, so I don't have a leadership role in that one. Jen Muller and Rita Ann O'Neill are doing an amazing job with that committee. But I think we are a growing group. We are women doing M&A deals throughout my career now, and I think I just hit my 19th anniversary with my firm.
Wow.
I've seen just a huge uptick in the number of women doing M&A, and it's wonderful. And this is a resource for us to compare notes, share information, network in ways that have been closed to us in the past.
And you guys sometimes get to work with each other?
Yes.
Oh, fantastic.
I can't elaborate on that, but yes.
So it sounds to me like beyond building friendships, you're learning, you're working together.
Networking leads to referral sources, leads to working together.
See, so it's all good.
Yeah.
So for a young lawyer who's thinking about becoming involved in the ABA, any advice for a young lawyer, especially one who's interested in M&A?
I think my primary advice would be come to the meetings.
Right.
Actually come. Like dialing in is great. You can hear a lot and you can learn a lot, but actually coming, you meet the people, they get to know you, you get to know them. That's where the networking happens. We are a very social group and a very welcoming group.
Right.
And that's where the opportunities come to really get involved, roll up your sleeves, and eventually move into the leadership ranks. And really, I think, make a name for yourself in the world of M&A as someone who is doing their best in this field.
And I know you're going to be in Las Vegas sometime soon. And what
Yes,
are you
the
going to be doing
National
there?
Institute.
And what's that all about?
So we'll have a mock negotiation of a transaction, which is
sounds
always
like
a lot of fun. We'll have panels on ancillary documents, a whole wide range of things. I think there's a brochure that just came out on that, and we encourage folks to attend. It's really a great 2 days of content.
Is there a particular level of attorney that you're gearing towards, or is this for all
I think
levels?
it's appropriate for all, and I would encourage firms to send their burgeoning attorneys, because this is a great way to get their feet wet and jump in and learn a lot about M&A all at once.
Because one of the unfortunate things of sort of clients being more cost conscious is the younger lawyers often, don't necessarily to get as involved in the deals as they can. And this is a great way to sort of actually see real deal lawyers negotiating a deal.
And I think it would be impossible to attend this and not come home with a new tip, a new piece of information, a new development in case law that you didn't know about before you came.
Oh, fantastic. So I know you're going to be the vice chair soon.
Yes.
So any ideas on what's going to change in the M&A committee, or we're just going to keep doing great things?
We've got fantastic folks leading our various subcommittees and task forces. We've got products coming in the next year, publications and development. I mentioned what we call MAPA 2, the second version of the Model Asset Purchase Agreement. That's in the pipeline. We've got various publications. I think we are not going to disrupt what's working.
The status quo.
Exactly. And I think you'll see more programs from our committee at future ABA meetings.
Oh, that sounds fantastic. Well, thank you so much for your time today. It's been a pleasure. So that concludes my interview with Jessica Pearlman from K&L Gates, one of the incoming vice chairs of the M&A committee.